We are now discussing constitutional law. This is the Clat lecture series sponsored by Sri Jayendra Rangzone. I am your mentor Shekhar Gelot. In the previous slides, we had discussed about the constitution and we were discussing about the fundamental rights. So Article 19 we were discussing, it gives us freedoms. Article 19 gives us freedoms, and we have 6 type of freedoms bestowed upon us by the Article 19. We have already discussed this freedom of speech and expressions. Now we'll begin with our next freedom, that is freedom to assemble peacefully and without arms. Now I have mentioned this Jallianwala Bagh here. This is the reason for this article or this freedom being crystallized. Okay, so naturally in any country people usually have freedom to assemble peacefully and without arms, but what happened, we all know this Jallianwala Bagh massacre is quite infamous because a gathering of peaceful people had assembled to protest some legislation by the British government, and one army of police, one army of police and other soldiers led by General Dyer entered into the park and opened fire on all the peaceful people who had assembled there to protest against the government. Thousands of people died in this. So when the country got independence, the scars of Jallianwala Bagh were still alive in the minds of constitutional framers, and this nightmare had haunted all the Indians till the time we got independence, and even after that. Its brutality became the reason for this particular freedom to be crystallized in writing, to assemble peacefully and without arms, so that in modern India, in the new India, after the Constitution India, post-Constitution India, no Jallianwala Bagh massacre is repeated by any government, okay, against the citizens. That is why this particular freedom found mention in Article 19. It says to assemble peacefully and without arms. So now now citizens of India have right to assemble and discuss or even criticize the government or the government policies. Now we can have even social and religious gatherings which are being held peacefully without any arms, and it also includes right not to form any association. That means you have a right to form association and right to assemble peacefully somewhere, but at the same time you have right not to form any association. That means no one could be compelled to be a part of some certain association. So when you have a right to form association, that is, this right is also called freedom to form association, assemble peacefully without arms. You have a freedom not to join or form any association as well. Suppose right now there are some associations in the country, like I say Congress, that is political party, then BJP is there, then RSS, Hindu ideologue, and AIMIM, and so like Shiv Sena and so many other fronts are there. So you have a right to join them. If you want to join Congress, BJP, RSS, or this any particular outfit, you have to comply with the formalities of these particular associations, and you can join them or be a part of them, or you can support them. But at the same time, if somebody doesn't want to support any of these ideologies, like I do not want to support Congress or the BJP at given point of time, nobody can compel me. Today we have a dispensation at the center which is led by the BJP front. Yesterday we had Congress. Tomorrow some other party may come up. So no other party or no other government can compel me to be a part of their agenda. Now today BJP is at the front, but BJP cannot compel me or any citizen to be a member of BJP, to form an association with the BJP. He or she is free to form any association or not to form any association of a dislike. Okay. Now, like we discussed that this freedom to speech and expression has certain restrictions. Every freedom given in the Article 19 have restrictions, reasonable restrictions associated with it. Now the restrictions along with this particular freedom is interest of sovereignty and integrity of India, just like J&K presently. We discussed this already. So government can put restrictions on the exercise of this right to assemble peacefully and without arms in the interest of sovereignty and integrity of India, just like we are seeing in the state of J&K. There has been a curfew in this particular state for almost 11 months. The security of the state, if the security of the state is threatened by our association, okay, then this can also be restricted. Like security of state, we can say simply friendly relations with the foreign state is also a part of the security of the state. Public order, okay, suppose there is some gathering which has a in which such slogans or speeches are being carried out or being such propaganda is being discussed that ultimately it may result into disturbance of the public order, public peace and tranquility, and it may prejudice to the general public. So that particular assembly can be restricted or can be banned from being held. Okay, like usually when there are protests against the government. So usually what people would do is, suppose people in Delhi, if they want to protest against the government, they will surround the parliament or assembly or monuments or buildings of high relevance. Similar is the case with any other state. So people surround those buildings like Vidhan Sabha or Rajya Sabha or Parliament or other. In that case, government may restrict that rally or may arrest those people who are assembling there because it is against the public order. Because we have so many places to assemble peacefully and without arms, we could have done it in some park or some open space. We should not, like Shaheen Bagh, we should not come straight away and sit in the public road. We cannot disturb public order. To form associations or unions, okay, to form associations or unions. Earlier this right was not there, this freedom was not there with us. So this is a part of a kind of, we may say it's a salutary labor reforms as well. Okay, this is a part of labor reforms as well, because these trade unions, earlier when these trade unions were not there, then the labor had a very limited bargaining power against the management. It was a labor versus management or factory as a whole dispute which started this unions. Okay, thereafter what laborers or these peoples or farmers started doing, they came together and forms association. Now association is a collective body, and collective body has a higher bargaining power. So now people, when they have arranged themselves in a collective body, they can definitely have a higher bargain power and they can muster the courage of raising their demands with the government or the representative at the center or the state. So trade unions, now we can legibly, laborers or other traders can legibly form their own trade unions. Earlier this was not allowed in the British Constitution or British India, but now it is allowed. College students and teachers can have their own unions, like we have student elections, student bodies. Okay, so students form up their own association or union for betterment of the facilities for the students in the particular college or the university. Similarly, teachers also have a union They demand better wages, better time scale, and so many other stuff. Political parties also come up under this particular genre, associations, and it also includes right not to form union or association. It also includes, similarly like we discussed, that includes right not to form association. You cannot be again compelled just because some association has come up. It doesn't mean every person or every trader has to be part of that particular trade union. They may choose not to be part of that trade union, or they may choose to form their own trade union, or they may choose to join that particular trade union. That is a complete freedom given to the citizen of India. It also has some restrictions. Restrictions are again interest of the sovereignty and integrity of India, just like J&K, the security of the state, public order, and morality. Now, one thing is very much important here, that every restriction, see, when we talk about Article 19, it has 6 freedoms. Okay, so with every 6 freedoms, restrictions are also written. Now, when the Constitution says that freedom of speech and expression can be restricted only in these conditions, then only in these conditions it could be restricted. Some new condition could not be brought in. Okay, some new condition could not be brought in. So every freedom has its own restrictions. Like speech has highest number of restrictions, 7 or 8 number of restrictions. Assemble without arms, it has only 3 number of restrictions. Now here we see form association and union, one more thing has been added here, one more kind of restriction has been added here, that is restriction of morality. Okay, so now government cannot have friendly relation with the foreign state as a restriction in this particular freedom. Okay, they cannot restrict this right, this freedom to form association or unions, because it entails into the it goes on to hurt the friend relations of the foreign state. Like I'll give you an example. We have friend relations with China. Okay, China is a country, India has a friendly relation. Okay, there may be some border tensions between the countries, but that is just part and part of day-to-day functioning or day-to-day affairs of the governments with each other who are sharing close borders. So, but on fairly large side, internationally, we may have some Cold War, but on papers we have friendly relations with the China. But we have a traders body called CAIT. This traders body is Central Association of Traders. Okay, these traders association, now they have given a call to boycott Chinese goods. Okay, so now this is a traders body. It says it has given a call to boycott Chinese goods, and so many traders are part of this particular association, and so many traders are now not buying or selling the Chinese goods, due to which China is suffering heavy loss, heavy monetary loss. China is suffering heavy monetary loss due to this call given by the CAT. Okay, this traders association. But now government of India cannot ban or restrict or prohibit the freedom of this particular association by saying that it threatens the friendly relation with China. Okay, friendly relations with the China. Why? Because this particular ground has not been mentioned here with this particular freedom. Okay, this particular ground has not been mentioned here. So government can impose only those restrictions which are mentioned here in the Constitution. No new restriction could be mentioned, could be brought in to curb your freedoms to move freely throughout the territory of India. Now that means we don't require any permission from the government to move within India, or there is no requirement like we have internationally. Visa requirements are there. So if you want to go to J&K or Rajasthan or Delhi or any other state, you are not required to procure some travel documents. Okay, you can do so freely if you are Indian citizen without any restriction. Now the reasonable restrictions in this particular freedom can be interest of general public or for the protection of interest of any scheduled tribe. So interest of general public, like right now you may be seeing that during COVID times, COVID-19 pandemic, many governments have closed down or shut down their borders, like Himachal Pradesh and Karnataka and Tamil Nadu too had some border issues during this lockdown. So largely many states said that we will not allow any movement to and fro from our state. Suppose Karnataka says, I will not allow any person other than Karnataka's person to enter the state or any person to leave the state. Now this becomes a restriction on your movement. But this restriction is a reasonable restriction. Why? Because this is allowed in the interest of general public. So when people will move to and fro, there is always a threat of pandemic going out of the hand, or it may be spreading at voluminous numbers. So just to prohibit this, just to in the interest of general public, many states or even the country as a whole underwent into a lockdown. Whole nation was locked down, markets were closed, you were not allowed to go out or roam around in open with leaving some emergency situation. So that is why there were restrictions. Your freedom to move freely throughout the territory was very much restricted. Forget the territory of India. During the lockdown, people were not allowed even to come out of their own houses. But that restriction is valid restriction, reasonable restrictions, because the Constitution of India permits interest restrictions in the interest of general public or for the protection of interest of any scheduled tribe. Like if you want to visit Arunachal Pradesh or Nagaland or Manipur or some parts of Himachal and J&K, some parts of Himachal or JK, these areas largely areas which are inhabited by the scheduled tribes, okay, and these scheduled tribes are those people who live in the hilly areas or in the dense forest, and they don't like to socialize with the urban people or the city people. They have their own lifestyles, okay. These people of scheduled tribes, they have their own lifestyle, they have their own culture, and they want to preserve it. They feel that their culture or their religion or their way of living is that will be at threat if foreign elements, if people from the city are allowed to occupy lands or come up and take up jobs in their areas. So they don't like it, and even government feels that these people right now are too backward in comparison to the urbanization. They are too backward right now from the other part of the country, and people from other part of the country, if they are allowed to venture into these areas, they may cause trouble or they may loot and plunder these people. They may they may abuse the innocence of these people. So restrictions can be placed in interest of any scheduled tribes, like they are there in these many areas, to reside and settle in any part of the territory of India. This is again a very valuable freedom which has been given to us. Now, earlier, when India became free, 15th of August 1947, India attained freedom. Okay, but just before that freedom, let's say 14th of August 1947, India was not the India which we see today. Like today we have 29 states and some 7 union territories, but that was not the case. That time there were almost 560 small states which had their own laws, which had their own requirements. They were operating like, in common words I can say, there were 560 mini countries within India. These all 560 small countries, small states, had their own ecosystem. Okay, they had their own ecosystem, their own terms and conditions. So when one person from one of these state wanted to go and settle in other state, he was required, subject to some taxation or some other requirement, some other compliances which he was supposed to follow, and this movement within the part of other state was not as free as it is today. Then later on, after the voluminous and very heroic efforts of our then Home Minister Shri Sardar Patel ji, these all 560 small states were consolidated and major states were carved out, and we had almost 21-22 states at the time of independence. Now, so that tomorrow these states do not put any restriction, okay, so that these states do not revert back to the this position, okay, because states have also been given different powers, they also have a lot of powers in the managing their own affairs, but in order to put a check on the state so that tomorrow they do not revert back to the pre-constitution era and start putting restriction over the movement of people or entry of people into their own state, this particular freedom has been made a part of the constitution of India. To reside and settle in any part of the territory of India, no state can put any unreasonable restrictions. Only restrictions are in the interest of general public, like we just discussed, or in the interest of any scheduled tribe. Okay, so you cannot even purchase land in these areas. Okay, you cannot purchase land. Any outsider from these particular states is not allowed to buy lands, and that is done only in the interest of scheduled tribes. There is no other reason. It is not that the government want to keep these areas out of the people, general people's approach, but no, because there are a lot of scheduled tribe people and government wants to protect their interest. To practice any profession or to carry on any occupation, trade or business. Okay, this freedom again has been a part of new India. Okay, new India, like in the old India, or we may say unregulated India, where traditional approaches were very high and people were very much frenetic about the religion. That time, caste used to be a deciding factor. Caste or place, family of birth used to be a deciding factor as to what one would study or do once he becomes a major, an adult. Okay, so many professions or so many trades were restricted as per the caste hierarchy, like a jeweler's son will only be a jeweler, or a cobbler's son will only be a cobbler, or a ruler's son will only be a ruler. It used to be like this, okay, and nobody was allowed or permitted to shift the occupation from the family occupation. So in order to break this mentality or this tradition wherein restrictions were placed upon the people depending upon the place of their birth or their family, their caste, this unhealthy system, in order to keep a check on it, it was mentioned in the Constitution of India in writing that people will be free, citizen will be free to practice any profession. Now even a cobbler's son wants to be a jeweler, he can be a jeweler, or a jeweler's son wants to be a cobbler, he can be a cobbler, no restriction now anymore. And a profession of to carry on any occupation, trade or business. So now we can carry on the activity, professional activity which suits us the most, not which society feels will suit us the most. Okay, restrictions in this regard can be the professional or technical qualifications, like government can always say that in order to carry on the practice of doctor, if you want to be a doctor you must first have MBBS. MBBS you must do in MBBS. If you want to be a lawyer, you must first complete your LLB studies. So now professional or technical qualifications government can definitely impose, and that is very reasonable as well, because even if anyone who starts become, anyone thinks like that I want to be a doctor and starts his own shop and starts prescribing medicines, it's going to be very harmful for the people of the country as a whole. And if somebody who's not fit to be a lawyer, who has not qualified LLB, wants to be a lawyer and says that because I have a freedom to practice any profession or carry on any occupation, trade, business by the Constitution of India, so now I want to be a lawyer, that will not be suitable in the interest of the general public. Okay, it will be doing more harm than the good. That is why the government can prescribe technical and professional qualifications like government has been doing since a long time. The carrying okay, it also gives some restrictions. It makes some restriction in the favor of the government. If any activity which government only wants to undertake, only government wishes to undertake, and government wants to exclude others, government says only I will do this particular activity, no private individual is allowed, or if somebody wants to do, he or she must take permission from government. That can very well be done. This is limited space given for the government, and some example of this is like government owned trades like nuclear activity, defense sector, petroleum, etc. So it is not easy, or it is not, it is not even safe for any private individual or a company without any permission from the government to set up their own nuclear facility or their own defense equipments or their own petroleum selling units. No, these are those trades in which government says that I will carry on these activities, or if you want to carry on the activities, you will have to take permission from me, and this restriction is a very valid restriction. Okay, but in this restriction, it is not that the government can make any restriction. Tomorrow government will say only government will run schools, and no private institution is allowed to run schools or colleges or educational institutions. That will not be a valid restriction. That restriction will fall flat on the face of it when taken to the court of law. Why? Because restrictions are always restrictions. When we talk about restrictions, restrictions have to be reasonable restrictions. Just because the government has been given power to exclude other people from a particular activity and to carry it on as a monopoly, it doesn't mean government will exclude any activity it feels like. Okay, so now these activities we understand: nuclear, defense sector, petroleum, these are those activities in which definitely government intervention has to be there. We cannot leave it on the capacity of the private individual or the private institution to enter into these activities. But education is totally different. From education is not carrying on of the nuclear activity. So here government cannot place restrictions using this restriction and say that no, only government will run the schoolings. No, government can run their schools parallelly, but even private institutions, if they want to carry on the education field, government cannot put unnecessary restrictions upon them. Now we come to our article 20. That is another fundamental right of very great importance. This article 20 has three parts. Okay, it begins with protection in respect of conviction of for offences. Conviction for offences means jail term or being found guilty. Okay, conviction or being found guilty simply means someone has committed an offense. A commits an offense, and he is found guilty by court of law. Okay, he is found guilty by the court of law, that then only this person can be called convicted or guilty. Just because police says, merely because police or state or government says X is murderer, X will not automatically become a murderer. unless the court of law decides so. Okay, nowadays this particular Sushant Singh Rajput and Riya Chakrabarti debate is going on at the TV. So many people, like even Sushant Singh Rajput's family, or even the media, or the government, or the police, or CBI, they are saying that Riya Chakrabarti is the real culprit, or she is the main kingpin in the drug scenario, and this and that. So they are calling Riya Chakrabarti, but now legally Riya Chakrabarti cannot be called to be a person who is convicted or found guilty of committing the crimes which government is saying. Even government, if says, even the government of India says Riya Chakrabarti is the real culprit, she won't be so till the time a court of law decides so. Okay, tomorrow a court of law, after going through all the examination of evidence, says that Riya Chakrabarti is one who should be held guilty for the murder or the suicide of this particular fellow Sushant Singh Rajput, then only we can implicate something to her. Otherwise she has a right to have a clean image. Okay, but in anyhow media uses or abuses its own right of freedom of speech and expression. So now let's go to the details of this particular article. Article 20, it says no person shall be convicted of any offense. Okay, no, like we have just understood what is conviction. Okay, no person shall be convicted of any offense except for the violation of the law in force at the time of the commission of act charged as an offense. Okay. This law simply says, if we break this law into parts, it says no person shall be convicted of any offense except for the violation of law in force at the time of the commission of offense. That means when A commits act B. Okay, now let's take the example of triple talaq. Triple talaq is a triple talaq was, I won't say is, used to be a practice within a particular community in the country in which they used to divorce, method of divorce to one's wife. Okay, so a Muslim male used to use this particular method of giving divorce to his wife, and this was allowed as per their own religious scriptures. Now this was perfectly okay, but in 2019 government of India banned use of this technique and even made it a criminal offense. So before 2018-19 this triple talaq was perfectly okay. It was a pan-India situation, but in 2018-19 government of India brought a law and said that from today onwards, if anybody uses triple talaq as a means of divorce to one's wife, it shall be a offense. So now it doesn't mean, suppose A divorced her wife just before the bill, just before this law, using triple talaq. So now A's wife cannot go to the court and complain that A has divorced me using triple talaq method and now he should be held guilty or he should be charged for the criminal activity. It cannot be done. So why? Because that particular point of time when he divorced, this law had not come. In our Constitution of India protects us. Constitution says that till the time that activity was not penalized in the law, nobody could be convicted of committing that offense. Okay, now onwards, if after 2018 or 19 somebody uses triple talaq, he has definitely committed an offense and he can be charged or convicted of that, of any offense of committing triple talaq, but not before that, because no person shall be convicted of any offense except for the violation of law in force at that time. So when this man, when A divorced his wife using triple talaq, this law was not in force at that time. Triple talaq law was not in force at that point of time. So when there was no law which criminalized that particular activity, therefore there was no offense committed. Or we can say nowadays people are dealing in Bitcoin. People are dealing in Bitcoin. The government of India is trying to bring a law and make it a criminal activity. But till the time the government of India does not bring a law and makes dealing in the Bitcoin a criminal activity, any person who deals in the Bitcoin will not automatically become a criminal or will not automatically become a person who has committed any offense. Why? Because when he is dealing in the when he is dealing in the Bitcoins, there is no law in force at the time which is being violated. Okay. So in order to become a violator of any law, there has to be a law. When there is no law at that particular given point of time, you cannot violate any particular law. So tomorrow, if government brings a law, government cannot straight away say just because you did it in the past and now today we have brought this law, now we will convict you as well. No, it can't be done. Only future cases can be decided, but not the cases which has already taken place. Plus, it also says no person shall be subjected to a penalty greater than that which might have been inflicted under the law in force of the time of the commission of offense. Okay, that means you cannot be given any greater penalty which is provided by the law at that particular time. I'll give you an example of like raping a minor. Okay, raping a minor now carries death penalty. Death penalty. Okay, so now if somebody is guilty of committing a rape upon a minor, the penalty inflicted by the law is death penalty, and that is the position after 2015-16. Okay, but before 2015-16, maximum punishment for committing rape was 10 years jail. Okay, 10 years jail. But anyhow, what happened, these number of cases became so much in numbers and so many minors were subjected to this ghastly act of this inhuman act of rape that parliament brought a law in 1516, and now the penalty for committing a rape upon the minor can go as high as up to death penalty. You can be sentenced to death as well. But before 2015-16, the law was not that harsh, not, I won't say harsh, but law was not that fine tuned towards for the time. It was only, gave only 10 years imprisonment in jail. So now X committed a rape upon minor in 2012. Okay, now his trial is going on, and as we all know, trial takes some time. Now his case is decided in year 2018. Okay, now when he committed the act, that was in year 2012, and now when the decision is being given in his case, that is year 2018, and meanwhile in between the law has been changed and now death penalty is inflicted for committing rape upon the minor. But constitution says though X's case is being decided in 2018, but when he committed rape, when he committed this particular offense, law shall be dealt for that particular point of time. What law will be applicable in 2018 upon this person will be decided as per time of the commission of offense. So in 2012, when he committed the offense, the penalty, maximum penalty was 10 years jail. Okay, 10 years jail. So though his case is being decided in 2018, now he cannot be given more than 10 years. Okay, Any person who commits a rape or who commits this particular offense after 2015-16 can be subjected to death penalty, but not those people who have committed this offense before this particular timeline, though their case may be decided later on, but they cannot be given more than 10 years jail term, because that is the protection given to us by the Constitution of India, which says no person shall be subjected to a penalty greater than that which might have been inflicted under the law enforced at the time of commission of the offense. So what is relevant here is time of commission of the offense, and not the time of sentence, not the time of sentence. Okay, so what is relevant in the Constitution is time of the commission of offense. When you committed this offense, that is in 2012, what was the law? Now you may be being sentenced in 2018, but the law shall be only one which was there in 2012. So this is the protection given by the Constitution of India for the citizens, so that government does not use the machinery of the law in order to curb the voices or the curb the criticism, okay, of the people of India by bringing new laws. When they have already committed a crime, then there cannot be any amendment, and they cannot be subjected to harsh punishments later on. This is also known as no ex post facto law. This is a legal term. Legal term in Latin, which we will discuss in detail when we will do our legal maxim and legal phrases. Okay, so this kind of law, you understand now the substance of the law is time of the offense is very critical, and no penalty or no offense when there was no such offense, or no higher law when there was no such law at that point of time. So this is also called the law of no ex post facto law. This is the triple talaq example which we have already discussed. No person shall be prosecuted and punished for the same offense more than once. It is also very relevant and a very important protection given to somebody who has committed an offense. Now A committed theft. Okay, A has committed theft. Now code of law says 3 years jail to A, and A has undergone those 3 years jail, and now A has come out of those jail. Now again state cannot say that you had committed offense that particular time, and we feel that 3 years was not appropriate, you should have been sentenced to 8 years, 8 years in jail. We will now retry you or reopen your case and commence a fresh trial and then sentence you to jail in 8 years. That cannot be done. Why? Because A has already been convicted by the court of law for 3 years in jail. Okay. So no person shall be prosecuted and punished for the same offense more than once. This is the substance of this particular law. This is also called no double jeopardy. This is again a legal term. This is a, which means you cannot jeopardize someone double, twice. You cannot jeopardize someone twice for committing one offense. Okay, when someone has already been sentenced or imprisoned once, you cannot re-prosecute him and re-punish him. You cannot punish someone double times, twice for committing one offense. Okay, for each offense there can be only one prosecution and one punishment. Punishment may be of any level. Okay, somebody commits a rape on a minor, he may be sentenced to the death penalty. Okay, he may be straight away given a death penalty. That is a different matter. But you cannot say that for committing rape of the minor we will kill you twice. Okay, but that is not practical. Or we will give you two different sentences. We will send you behind the bars for 10 years as well, and then we will later on in the 11th years we will inflict death penalty upon you. This cannot be done. Either you send him in the jail for 10 years or you inflict a death penalty. There can be only one penalty upon a person, and he cannot be penalized twice for committing same offense. Okay, for committing one offense. This is also known as the law of no double jeopardy. That means you cannot jeopardize somebody's interest twice for committing one offense. Okay, however, appeal is different than prosecution, and proceedings in appeal should not be confused with the double prosecution. Okay, so prosecution, this word prosecuted or this word prosecution means when you are being tried in the court of law. Now court A says 3 years to jail. Now in this case straight away government can go in appeal to a higher court. Government could go in appeal to a higher court. Okay, and then higher court could give him 8 years. Okay, that is only a continuation of the prosecution. That is only a continuation. Appeal is only a continuation of the earlier prosecution. But it cannot be like that government did not go into appeal at that point of time. Now after 3 years when he has come out of the jail, now government wants to again go to the court for these 8 years. That cannot be done. Okay, appeal and fresh prosecution is different. Okay, so no appeal should be confused with a fresh prosecution itself. Now, third right is the right of no person accused of any offense shall be compelled to be a witness against himself. This is also a very big right, this very important right in the criminal justice system, and it protects innocent people from state's power to torture. Okay, suppose A commits an offense. A has committed an offense. We are taking this as an example, but we cannot say he has committed an offense till the time court of law says that A is the one who actually committed an offense. Today what is happening is, today police says that as per police, A has committed the offense. Okay, now what is police? Police is state or the state machinery only. Police is the state machinery or part of the state machinery only. Now police has all the might with it. Police can put this person behind the bars, and then 4 or 5 police people can commit torture on this person and make him write down something in which he says that yes, I admit that I have committed this offense. Okay, this cannot be done. Law says even if A admits that he has committed offense, okay, this statement shall have no relevance in law. Okay, this statement shall have no relevance in law even if police has a paper written on which A has written that I admit that I have committed this offense, and even A has signed it, and police takes it to the court. The court shall not read this statement as part of the evidence, or this statement shall not mean anything at all in the law. Okay, why? Because the Constitution of India says no person accused of any offense shall be compelled to be a witness against himself. So if anyone who has made this statement to the police and tomorrow in the court he says no, I did not make this statement, I was compelled to do so, then that statement will have to go away. It will no longer be part of the evidence, or the no court in the law can decide its case upon that statement. Okay, this statement shall not be read against A. But yes, if he goes to the court and he willingly says that I willingly admit that I have committed this offense, then no problem. Court can believe on that statement and hold him guilty, but he cannot be compelled. That statement should come willingly, that should not come out of compulsion. Okay, so nobody can be, police cannot compel someone by using torture or other means. Degree, like it was a very infamous situation in the state of Tamil Nadu when two fathers son duo Jairaj and Benik, they were tortured by the police. This cannot be done by the police, and when police torture someone and extracts some some statement from him that I have committed the offense, this statement holds no water in court of law. It is also called rule of no self incrimination. Incrimination means when you are incriminating or pointing fingers. Okay, no self incrimination, no self pointing of fingers. You are not allowed to point fingers at yourself. Okay, you cannot say that I have committed the offense. Obviously, if you are going to say this out of your own willingness, that is okay, but if you say that I made this statement under compulsion, that statement will not be read against you. It will go in the court of law. So this is a brief description. I have explained it, but I have left this description. You can pause it and read it here whenever you feel to have a greater understanding of the concept. Now we come to Article 21. Article 21 is a very relevant article. Uh, this article says it's only a 3-line article. No person shall be deprived of his life or personal liberty except according to the procedure established by law. No person shall be deprived of his life and personal liberty except according to the procedure established by law. This article started as an article which prevents from arbitrary arrest, detention and punishment by police and the government authorities. However, over the course of time, this article has become a hallmark of Indian system, and now through various judicial orders, Article 21 includes so many other rights. Some are reproduced below. Okay, so if we read only this bare text, this text of the what this article is, no person shall be deprived of his life. I am making groups. No person shall deprived of his life or personal liberty except according to the procedure established by law. However, this particular article requires some detailed and deliberate discussion. So we will now conclude this particular slide and we will again take up this article in the next slide. Thank you.